session is a case study presentation. The topic of the presentation is building your organization's cyber resilience, what in-house counsels can do. And our first speaker is Zhen Guang, Senior Associate at Clyde & Co. Please welcome him with a big hand. Our second speaker is Mr. Philip Chua, Group Senior Technology Counsel at AIA. And we will be having Ms. Voon, who will be moderating the session for us, APAC Regional Counsel, Cyber Risk at Kroll. Kroll is also one of the sponsors for the conference, and we have the exhibition booth right at the back, so please feel free to reach out to her specifically for any questions. Thank you.
Thank you, Bharti. Hi, everyone. My name is Voon. I'm the APAC Regional Counsel for Kroll. Kroll provides risk advisory services globally, including end-to-end cybersecurity services. So I'm very pleased to have with me the two guest speakers that Bharti has introduced. Of course, Philip is our keynote speaker from this morning. And Guang, he's Senior Associate at Clyde & Co. He specializes in data protection, TMT, as well as cybersecurity. So as we all know, cyber attackers, they know no boundaries. You can be located in the most physically secure locations and yet be vulnerable to cyber attacks. And so we all have to be vigilant, and we believe that counsel should take a proactive approach towards cybersecurity. In Kroll's State of the Incident Response Report published just last month, in APAC, it was found that 59% of companies have encountered a cyber attack and 32% have faced repeated attacks. At Kroll, we believe that in-house counsels, you are the incident response quarterback. You guide your team and you determine the outcome of the game. And so today we'd like to talk about 5 areas in which legal can play a key role, a central role, to help their organizations enhance their cyber resilience. So first, write and practice an incident response plan. An incident response plan, or an IR plan, is like a roadmap or playbook that should set out who is to do what in the event of a cyber incident. And you should also test and practice that plan to build that muscle memory so that you can implement it easily if you do get hit by a cyber incident. And also make sure that you update it with new scenarios and the latest cyber threats to make sure, because these threats are constantly evolving. And so my first question to our panel is, would you agree that legal should play a central role in the writing and practicing of an incident response plan? Philip, would you like to go first?
Okay. So I have to be a bit careful when in giving my answer. So, I mean, I'm going to speak to the perspective of AIA, right? So we don't publish, of course, and we don't broadcast, data breaches or potential data breaches that we face, right? But as I mentioned this morning, as part of our approach with regulators, we are required to produce how we would respond to such a breach, right? In most times, it falls on the role of the legal counsel to coordinate a response. And that's because a lot of times when a breach happens, the first thing that comes to mind, especially for us, is how do we manage regulators, right? How much do we tell them? When do we tell them? Do we even need to tell them? And then, that's the primary focus of our response, and that's why it falls on the legal counsel. I have a different view, and this is where we're trying to pivot towards, right? Because when a breach happens, it is not just a response to the regulators that is important. It is a response to the policy holders that we are accountable to, right? And it's not just for that incident in and of itself. You can resolve it at the end of the day, whether it's internal or it's with the vendor. But it's also about what do you do moving forward in terms of prevention, right? And maintaining that preventive measure, right? Because what you don't want to do is put in a process, and then after 6 months or a year, that process is no longer followed, right? And in that regard, I don't feel the role of the legal counsel should be the quarterback for that, right? Because that requires a holistic team, right? So in AIA, when something like that happens, we, of course, our group information security team is involved. We get involved, our operational risk compliance team, our group audit team comes alongside us, as well as the responsible business unit, right? Depending on where the potential breach has emanated from. And then, of course, with the agency force as well in terms of whether any policy holder is impacted, right? So it's actually a team that comes together, right? And, you know, as I mentioned, the role of the legal counsel at the outset in responding to the regulators, yes, that's our role, our primary role, and we do most of the coordination with that. But beyond that, it cannot be the role of the legal counsel to lead that. We can facilitate it, and we should definitely insist upon it because it's part of compliance, right? But that role should be undertaken by other functions within the organization. I mean, so that's how we have been practicing it, or we're trying to pivot to that practice.
Understand. Zhen Guang?
Thanks, Rob. Thanks, Don. So I believe Philip has touched on, I think, post-incident issues. For example, who do you involve when there's an incident, the action items, as well as who to interface with the regulator. I guess how, for an outside counsel like myself, I'll approach this in two angles. The first would be pre-incident, and the second would be during and after the incident. And I'll elaborate more on the pre-incident action items that generally in-house counsels should take note of and how they can play a key role. So I'm sure, as a certain famous boxer once said, everybody has a plan until they're punched in the mouth. So I would just add on to that in that with regard to an incident response plan, yes, you're hit by a cyber attack or a data breach, but at least you are not scrambling at that point in time. You know what is going on because you have a written plan in place. The key personnel know what to do and to therefore execute it. So generally how I see is that for pre-incident action items, the legal counsel is important in the sense of being like a project manager, coordinating with the different managements within the organizations. So for example, the IT head, the compliance head, if there's a data protection officer, him or her as well. And of course, other teams where there are a lot of personal data that's managed by them. So for example, like the marketing team, or let's say the HR department. And so the legal counsel, what we notice is that in an organization that has a very robust incident response plan, the in-house counsel generally is the one that helps to facilitate the exercise, the adoption, the execution of this plan. So for example, by engaging in informal discussions with the different people, let's say in HR, marketing, or with the key management holders, the legal counsel can also, say, organize or get in touch with external vendors to organize tabletop exercises or even carry out simulation exercises so that to better prepare the organization. So overall, it's really a case where we want to make sure that your organization has something prepared. So in the event of a cyber attack or say a data breach, at least everybody knows what to do, what to carry out, and more importantly, to actually minimize any consequences or implication that follows after an incident.
Thanks, Zhen Guang. Yes, it is definitely important to practice it through tabletop exercises, as Zhen Guang said. And the next area, which hopefully this is an area that Philip agrees that legal can play, can be the quarterback, which is breach notification. Because legal, of course, we play a key role in determining whether a security incident has triggered certain breach notification obligations under the relevant laws and regulations. So the applicable laws and regulations would depend on factors such as the location of the breach and the data subjects. And And linking back to the first point of our first point on incident response plan, you should definitely include on your IR plan a clearly defined process on making of this breach notification. So my question to the panel is, do you have any tips or guidance for companies who have to make the breach notification, particularly with a view to mitigating their reputational risk? Zhen Guang, please.
Thanks, Don. I think the starting point is to be aware the different types of notification that an organization is required to make, or at least it should consider making. So the first type, as most of us would know, would be whether is this an incident that is notifiable to regulators or even law enforcement agencies. So in terms of, let's say, minimizing any reputational risk, what we do notice in terms of the data breach incidents that I've handled is for those that actually end up with a good ending, what we notice is that they are very careful, but of course open in terms of how they communicate with the regulator. So from our experience is that, I'm not sure whether there are any regulators here in the room, but in terms of sharing of information, that is part and parcel when you're communicating or when you're notifying the regulator. And generally it's viewed positively if you can show that you are transparent, you are open, you are trying to help not only the organization, but more importantly, the affected individuals as well as the regulator in resolving the matter. Of course, there might be, say, implications, any non-compliance issues that follow after, but at least in terms of your attitude, your response, your notification to the regulator, there's a positive light that they will take note. So just want to end off with the other type of notification, which is generally to affected individuals, as well as, say, your corporate partners or corporate customers. And for those type of notifications, I guess the starting point that you might want to consider is it something that is legally required? Is this something that is required by regulation? Because that will impact how you want to deal with it and generally how you want to respond to the different types of affected customers as well as corporate members. So how I see is that generally you would want to be very, very careful in how you want to actually address, because essentially, if you think about it, you're breaking bad news to a person. And if you're breaking bad news to a person, you have to make sure how I'm going to approach it such that I can actually minimize any potential claims against me later. So generally what we notice for the better notifications to affected individuals and corporate customers would be a case where they offer, or at least they extend a hand in terms of, hey, we are able to offer FOC, complimentary credit or ID monitoring to you if you're willing to take it up. So that sort of softens the blow when you're breaking the bad news to the person. So that's essentially the two types of notification and how generally one can minimize the reputational risk that comes along with it.
And Philip, please.
I think Zhen Guang has mentioned everything that we hold, the principles that we hold dear in AIA in a situation like that. So I think just to add, what we practice is in a situation like this, we believe more is more, not less is more, right? So we also firmly believe regulators are appreciative if you are transparent with them, right? So at most they'll tell you is that, okay, actually you didn't need to notify us on this, and then all is good, right? Because the last thing we want is the regulators to find out through other means, right? As well as to policyholders, right? It's not just to let them know something has happened, but also to help protect them or help them be aware that if they have any doubts, right, we are there alongside them, right, to help them manage the situation and extend the resources that we have to them as well.
Thank you both. Yeah, very good practical tips. The third area that legal counsel can play a key role is to line up your key vendors beforehand. So legal should definitely negotiate contracts with external vendors before an incident. It's not advisable to start your contract wrangling and ding-donging on legal terms with your vendors during an incident, because this can cause critical delays. Ransomware can spread quickly to more systems, encrypt more data, and also the threat actor can enter the network and steal more data. And in the meantime, the evidence of the threat actor activity is not preserved, as the data is quickly overwritten. And so take out an incident response retainer so that your forensic expert can quickly get on the ground wherever your offices may be located and then respond usually within 4 to 6 hours and quickly help you to determine the root cause of the breach and contain the threat. So my question to the panel is, what are the critical vendors companies should have in place to help them respond quickly and effectively to an incident? Philip, please.
Okay, so let me do some marketing for Kroll. So, so as I mentioned earlier this morning, right, we as big as an organization as we are, right, we don't have all the technology skills and we don't have all the resources that, that are available, right, as and when we need them. So we rely a lot on our vendors, right, to be good partners with us. So one of the key vendors is actually forensic, to have a forensic analysis vendor at our disposal, because incidents, as you well know, they are more frequent than that is reported in the press, right? So I couldn't agree with you, Don, more, that it is always advisable to have something in place first. And with a strategic vendor, like for ourselves, we consider Kroll a strategic vendor. But the relationship we have with Kroll is a fairly new one, right? And we didn't have the time to come up with a pre-contract contract retainer scheme, but I think to Kroll's credit, they have responded even in the absence of a contract while we work out the paperwork, right? So I think for us, we appreciate vendors of that nature, right? Because they understand the criticality of the time factor as well. But of course, in best practice, we should have one in place before an incident happened. And, I can't say, any more good things than I have already for an organization like Kroll.
Oh, thank you, Philip, for your kind words. Actually, you do have a retainer. So the beauty, yeah, exactly. That's the beauty of the retainer, because after that, we just need to agree on scope. So, like in the course of time, from time to time, small incidents can crop up, and then your incident responder will be able to quickly respond to your instructions and get on the ground, because all the legal terms already have been agreed. Maybe even years ago. So, Zhen Guang, do you have anything to add?
Sure. So for those who might not know, so Clyde & Co, my firm, together with Kroll, I think we are currently assisting with an investigation for, I think, a matter at the moment, a potential data breach, where we are deciding whether is this a notifiable incident or not. And in terms of the key vendors, based on my experience, as I'm involved in the incident as well, is, for example, Kroll, they're able to step up to actually deliver in terms of the IT forensic services, in terms of providing a intel intelligence in terms of who this threat actor is, what is his or her or even their modus operandi, which is very useful for not only to the client, but also to us, because in terms of our role as outside counsels, we can advise the client in terms of, okay, is this a case where we're dealing with a very sophisticated threat actor? Or is this a case where this person just wants money, and if you think about paying him off, that might actually resolve the incident much quicker. So one thing to also note is that for key vendors, generally we think of vendors as each person delivering a particular set of skills. But there are times where, from our experience with Kroll, is that they're able to deliver in terms of a fuller service. So for example, not just in terms of the IT forensic, but in terms of subsequently, if we are dealing with unstructured data, they are able to do in terms of the data mining exercises to actually filter out the relevant personal data so that we can notify the affected individuals. So if you can find a vendor that is able to offer not just one particular service, but a multitude of different services, cling on to that person, don't let him go, because he or she will be very valuable in terms of when the incident next hits you.
That is very good advice, Zhen Guang. Thank you so much. And the next area we want to go into is to implement managed detection and response, or MDR. So this is a managed automated platform which are installed on your company's endpoints that can enable quicker detection and response, but also more robust events logging. It is just too late to start logging after an incident because as I mentioned earlier, data is quickly overwritten due to the computer's processes. So take out an MDR so that you will have an accurate and detailed playback of the threat actor activity, which in the hands of your forensic practitioner, he can interpret that data and give you an opinion, such as did the threat actor only access your system or did he actually exfiltrate the data? And then legal, you can look at that opinion and come up with your legal analysis as to what are the legal risks arising from this cyber incident. So my question to the panel is, do you think that having an MDR partner in place will help legal to perform their incident response roles more effectively? Perhaps Zhen Guang?
Sure. So I think one thing that everybody in this room would probably know is that whether you're in-house counsel or if you're outside counsel like myself, you're overworked to start with. You have limited budget, you have insufficient resources, your superior is chasing you for work that's way overdue. So the starting point is that if you are able to outsource as much work as possible to external vendors, of course, subject to your budget, then that will be most welcoming. So in that sense, MDP, I think the services that Dawn has mentioned, that is something very useful because especially in times of crisis like a cyber incident that hits you, you want to actually make sure that your limited resources are directed to the things that are more important. So in terms of an MDR, what we notice is that it helps in terms of elevating the day-to-day operational burden that, let's say, the legal counsel or the IT person is managing. It also helps in terms of weeding out false positives. So for example, if, let's say, a company that does not have such a service in place, what it's being alerted to are alerts, but not indicators. And there is a major difference between the two. Because for every alert that you have to direct your attention to, there's limited resources that can be better off spent elsewhere. But if, let's say, you have such a service in place, and what we do observe is that you actually look out for the indicators so that you can actually respond to such a threat and preempt it before it even happened. So that's something that is very useful, especially for companies, for organizations that deal with a very large volume of personal data or confidential commercial data.
Thanks, Zhen Guang. Philip?
I think Chen Guang has summarized it really well. I think everything that we have experienced at AIA and what we practice in is exactly what has been mentioned. I think at most times, whenever there is a threat, I think studies have shown that you generally don't know that you have been hacked until the data is being extracted. That's when you have your first sign, right? So having a system like that, especially for us, right, as a regulated industry where we hold personal information, right, and confidential information and health information of our policyholder, that becomes extremely critical.
Thanks, Philip. And the final area that we want to talk about is cyber insurance. Take out an appropriate cyber policy that is relevant to your business risk. But of course, so we know that cyber insurance can cover things like stolen monies, ransomware payout, cost of forensic investigator, your regulatory penalties. But the thing with cyber insurance is that the deductibles are very high. So for your to cover also your smaller losses and incidents, take out also complement your policy with an incident response retainer. Because then you can, for those smaller incidents, you can tap into your retainer and avoid having to make a claim under your policy, which can affect your loss record, leading to higher premiums. And also the thing with insurance, of course, is if you don't make a claim, then you would have paid the premium and not recovered the cost of that premium. But with a retainer, even if you don't experience an incident, during the year, you can still use your retainer for essential cyber services. So for example, the services we talk about, like tabletop exercises and MDR. So you would definitely extract value from your retainer. My question to the panel is, directly on the insurance is, what are the factors do you think that companies should consider when deciding whether to purchase a cyber policy and also the scope of coverage to buy? Philip, please.
I suppose being working for an insurance company, we self-insure a lot of our own things, right? So, but let me answer that through the perspective of our engagement with vendors. Because we use a lot of vendors, right? As I mentioned earlier, we are a cloud-first company. So our first preference is to engage with vendors who are themselves providing their offerings on the cloud. So and at times, a lot of times, right, when we engage these vendors, it is to process our data in some shape or form, right? So they hold our data, right? So with these vendors, we are especially sensitive, right? In terms of how they protect the data. But even though money can't solve, even if we get paid, if they breach and we get paid a certain sum of money, it doesn't change our world, but the pain is even more pronounced, right? But we still do ask our vendors to purchase cyber insurance, right? So that at least we know that when an incident happens, right, and then if we ourselves have to then take the remediation action, right, in dealing with the regulators or dealing with our policyholders or offering, as what Guang mentioned earlier, services to our policyholders, right, to keep them safe, right? At least we know that there is, the vendors themselves, right, have a bucket of monies that they can spend, right, to offset some of these costs, as well as to fix whatever issues that caused the breach in the first place.
About cyber insurance, see, I don't know what is covered in it, but your agreement will have a clause of indemnification. The vendor has to indemnify you if there is any breach on his part, which includes some cost which is saddled on you by the actual person who has suffered the damage. Like in your case, my details are with you and it is breached and it goes into somebody's, somebody, and therefore I sue you because, the company has not done it. So what is the additional benefit which I get in a cyber insurance, and what is covered? Only the cost, the monetary aspect is only covered. And I don't think, the reputational loss or the penalty which your regulator may impose on you, that cannot be covered. I just want to get a clarification.
Yeah, that's a good point, right? Because when we so this is one of the topics that sometimes we debate with our vendors, right? The extent and scope of the indemnity, right? Because of the nature of the service that they are providing and the nature of the data that they're holding for us, right? So if there's a breach, right, then it causes us a world of pain, right? And then we have to spend time and money and, maybe in some cases pay regulator fines or, compensate our policyholders in some shape or form, right? Or in some respects to take our own remediation action, right? Which would then mean additional investment on our part. So most of the times, when we debate this with vendors, right, we try to push all this under the indemnity, but vendors will always tell us, these are all indirect damages and therefore doesn't fall within, the indemnity provision. Right, or these will be, or breaches of this nature are not subject to indemnity but to a cap, right? Because I don't know how long a piece of string is, right? That's usually the argument, right? So one of the ways in which we try to circumnavigate this, right, because sometimes it can be long and drawn out, right, is take up the insurance, show us the value of the insurance that you take up. If we are happy with that insurance, then we don't even need to worry about the indemnity discussion any longer, because I know that you will have the monies in hand and we deal with that on a separate basis, right? Because at the end of the day, we want to do what is practical rather than argue on a legal point as to whether or not do you consider this consequential damages or direct damages, right? And whether it should be form part of the indemnity provision or the cap. right? Which can be very long, drawn-out discussion. So that's why we normally insist on these types of insurance, but it depends as well on the nature of the work the vendor does for us. We don't insist on all the vendors, right? Some we feel are not really necessary depending on the volume of work, the type of work, and the value of the contract, right? Because we understand it is a cost to the vendor. And if the vendor themselves don't have an existing policy and have to purchase one just for us, we know it's going to find its way back in the price, back to us, right? Which in some cases we are happy to pay, right? If it provides that level of comfort that we are looking for. Yeah.
Thanks, Philip. Zhen Guang?
I think one thing to add is from when you're buying insurance, naturally there'll be premiums to be paid. And so that's where your finance team comes knocking on your door. How much are we paying? How long is it for? And more importantly, is it worth it? So I think you have to be very clear as to what you are paying. And not only in terms of what does, let's say if you want to make a claim, what does it consist of or what is excluded, but whether are you buying more than necessary. So just to share, I think one of the experiences that I have is we have a client at the moment. They suffered a cyber attack. And so it was a ransomware attack that was that sort of targeted their IT servers. And so I think in the first instance, what the management decided that based on policy reasons, we are not going to pay the ransom. This is to show that our position is very clear. We do not fall to threat actors like these ransomware attackers. And so then the legal, the compliance, the finance team started looking at their cyber insurance after that, and then they noticed that, hang on a second, it seems like our cyber insurance covers ransomware attacks and, more importantly, payment of the ransom if the company wishes to do so. So then that begs the question as to why such an ancillary cover was bought in the first place when they could have did away with it due to the policy reason not to pay any threat actors like this ransomware attacker, and then save on the premiums. So essentially, you need to know what you are paying for. If there are certain things due to policy reasons, due to your HQ reasons that you do not have to pay for or you have to pay for, then be very clear before purchasing the cyber insurance policy.
Thank you very much, Zhen Guang. And so I think we are running out of time. So I just would like to thank our guest speakers, but also hope that the point that you take our point that companies should take cybersecurity seriously. And if you have any questions, I think we'll all be here. You can ask us during lunch or come and talk to us. Our Kroll booth is behind. We'll be able to help with your cyber protection as well as dealing with any incidents, prepare for incidents. Thank you very much.
Thank you.